Good morning, everyone. My name is Manu from the Forest for Climate and People project research. It is done with the collaboration of the University of Antananarivo and Bangor University. Today, I am pleased to share with you one of the results of our research that have been led in the project. We will then talk about a legal review of land tenure and forest landscape restoration in Madagascar, their limitations and policy recommendations. As we may know, trees and forests play an important role for both humans and our climate. This ecosystem provides many services that could contribute to human well-being and to the climate through its regulation role by being a carbon sink. The conservation and restoration of these ecosystems has then become very important in recent years and have been particularly highlighted during the climate change solution in COP26 in Glasgow. Many countries have been convinced about this solution and have committed to conserve and restore their forest landscape. Madagascar also has made a commitment to restore 4 million hectares of forest landscape by 2030. 5 priorities landscapes have been identified for that: the restoration of natural forest, the reforestation of degraded land, the restoration of mangroves, pen plantations, and agroforestry landscapes. Although the implementation of forest landscape restoration can provide so many benefits for humans, biodiversity and climate, it can also exacerbate poverty in the community concerned if its implementation leads to restriction on access, rights, and use of land for these people. The National Strategy of Restoration in Madagascar even mentions that land use is one of the major challenges in the implementation of FLR, given the ambiguities that exist on the law. In order to make the implementation of FLR effective and equitable, we have tried to identify these various inconsistencies and limitations that may affect FLR in Madagascar. We then analyzed the elaborated national strategies, public policies, national visions, laws, decrees, and ordinances that are related to land tenure and landscape restoration. 4 important points have been raised through the analysis. The first is related to the availability of land for restoration. Indeed, there is a difficulty in identifying and demarcating state for land for restorations. Before the reform of the 2005 land law, every land that is not titled to private individuals is immediately considered as the state land. But such principle of state ownership was later removed. However, the state lands intended for forestation that were targeted by Law 2000 were not physically demarcated and were subsequently appropriated by occupants. On the other hand, the restoration of protected areas is also problematic because of the protected area created after 2005 are concerned by mixed land statute, as they have already been occupied or even inhabited. Secondly, there is a problem of securing restoration land. The law allows the population to legalize the appropriation of the land that they have enhanced through agricultural practices or tree planting, but the procedures to obtain certificate through it after is very long and cost much to people. One issue concerns also the sustainability of this restored land. According to the private law land, the owner is no longer subject to any obligation to prescribe the use of this land, which can then lead to the allocation of the reforested land to other use. Apart from that, for those who wish to keep their land as reforestation land, the use of native species risks the loss of their right into their land to forested land because there is a lack of clarity on Law 97 on the definition of forested land. And finally, Because of the lack of concrete financial support, people are struggling to get a return on their investment through restoration. The only promised benefits come from REDD+ funding, which until now has been sporadic or non-existent. The third point raised by our analysis that may threaten the effectiveness of FLR implementation is the unrecognition of the land ownership rights of the local community and the community entity that is called Fukunula here in Madagascar. In fact, on land with specific status, such as protected areas, restoration zones, no recognition of untethered appropriation rights can be made. However, as I often explained before, these areas were already occupied long before. This can undermine the community's property rights. The same is true for community forests, despite the fact that these areas have always been managed and appropriated locally. The law only recognizes the right of use and they only rewards this right when expropriating the local population for the conservation or restoration action. And finally, for agroforestry areas, especially for large pastures, the right of community entities, who is the Fukunul, that is customarily in charge are not recognized because such an entity is not considered as a legal person here in Madagascar. As a result, the restoration of these areas risks to lead to privatized appropriation that could affect an entire community. The last point raised is the lack of synergy and collaboration between the ministries involved in restoration. Given that forest landscape restoration is intersectorial, there are conflicts of responsibilities in the text. For example, the forestry law indicates the Forestry Commission to be in charge of the identification of restoration areas, while the land use planning law indicates this responsibility for the technical services. On the other hand, existing state forest and restoration areas do not appear in official state land use plan documents. This often leads to overlapping titles on these lands, as people obtain titles in protected areas or restoration areas long after they have been created. And finally, for the practical activity in the restoration, no collaborative action have been taken between ministries. This is also the case for the pastoral land restoration, and it seems that the use of tree is competing over types of use between sectors. So, in relation to all these points that have been raised, we suggest that the state land to be used for restoration should be identified in participatory way, and the legal regimes of special status areas should be specified to remove any confusion in their management and use. We also propose to provide significant financial incentives for the implementation of FLR, especially for the local community. For example, by facilitating the appropriation of restored land, and also by giving them financial aid. It is also necessary to ensure that the rights of local community and the Fukunul are considered and secured, so the participation will be effective and does not increase their poverty. And finally, a closer collaboration of ministries is expected to allow current actions with more impact for both the community and nature. So these are our results and recommendations. Thank you very much for your attention, and please do not hesitate if you have any eventual question. Thank you.